Um, The next topic would be scheduling pre-election hearings. Can Maury Baskin, Jonathan Fritz, and Karen Sensor approach, please? You may proceed.
Good morning. My name is Maury Baskin. I'm a shareholder with the National Labor and Employment Law firm Littler Mendelsohn and Littler's Workplace Policy Institute. I'm here representing Associated Builders and Contractors, ABC, the National Trade Association of Merit Shop Construction, and with me is Lauren Williams from the ABC staff. ABC strongly opposes many aspects of the proposed rule. I think it's fair to say that the credibility of this board as a neutral administrator of the Labor Act is at stake here. As we said in our written comments, these are the most radical and sweeping proposed changes to the board's election case handling regulations in at least 50 years. And since no serious problems with the current system have been identified, employers understandably think there is a nefarious purpose behind these proposals. So we urge you to withdraw them entirely. But with that introduction, let me focus, as you requested, on the single proposal that is the subject of this panel, namely the board majority's proposal to shorten the time between union election petitions and the statutorily required pre-election hearing. The proposed new rule says hearings shall be scheduled within 7 days of petition filing except for undefined special circumstances. There's been some confusion about exactly what's intended by that. There's some reference to codifying current law, but that is definitely not the current practice. The current practice is hearings are held anywhere between 7 and 14 days. Requests for postponement are, on sufficient grounds, are routinely granted, as they should be, because 7 days has been the bare minimum, and in many, if not most cases, employers simply cannot prepare intelligently for the types of issues that are going to be raised at these hearings in just the 7 days. And I should add that looking around the federal government, 14 days seems to be becoming a standard for notice of hearings in other contexts. One need only look at your own regulations. 14 days is the minimum for unfair labor practice hearings, and of course we know they are actually usually noticed much farther away than that. The U.S. Department of Labor's Office of Administrative Law Judges, which conducts hearings under some 60 different federal laws, they've announced proposed an interim final rule going with 14 days. They're even the definition of fair hearings under such laws as Medicaid and Social Security, they're going with 14 days. So our recommendation is that you should go with 14 days. You certainly should not be shortening the process if that's what's intended by the proposed rule, which is what most people think you intend. And if you don't intend, just say so, I'll go home. But people think that, because otherwise, why make the changes at all? Why are you proposing changes from a system that seems to be working okay? We see no reason for the board to be a rogue agency that gives employers so little notice of pre-election hearings. I would say further that we represent a lot of small employers, but also big ones. They both have problems with preparing for these hearings. The smaller ones, particularly in the construction industry, they don't have the resources. They don't have HR directors. They don't have lawyers on staff or even on speed dial. And maybe they're members of ABC, the smart ones. But even there, they have to know that they even need a lawyer. They have to know that there is a National Labor Relations Board. And many of them know that much, but they don't know what's involved in this process. The issues that affect construction contractors in particular, but many other types of employers have these very complicated unit issues. They're just more so in the construction industry, terms like DECLUA and single employers and multi-sites and crafts. And then you brought in this specialty healthcare concept, which may not even apply to the construction industry, but we're seeing regional directors starting to apply it. And so it's a question, an issue that should be raised. The contractors don't know it. The larger contractors also have issues. They have more resources, but they have more projects. They have people all over the place. And in the construction industry, recognized by the Labor Department as having a uniquely fluid, contemporary, ever-changing workforce, much harder to keep track of. We'll hear more about that when we discuss things like the voter eligibility list and the statement of position. It all boils down to the fact that 7 days is the bare minimum, and for the contractor and employer that's ready, fine, but in most cases, they are not ready. They can't even reach their lawyer. The lawyer's not ready, has other things that are about to happen, and it should not stand in the way. Some arbitrary minimum time like this should not stand in the way of protecting the rights of employers, employees, and unions to a fair due process in the hearing. So that's what I've got to say.
Do you think that there should be a timeline for scheduling that hearing?
Well, the way it's been working is 10 to 14 days, 10 to start, 7 sometimes. Some of the regional directors are doing it, and with setting it to 14 days. We think when the need arises, it should be extended beyond that. There's no need to rush to judgment, which is what a lot of these rules seem to be about.
Do you think that it should just be based on whatever that regional director does and have that sort of difference among the regions across the country?
Actually, not a big fan of the differences of regions around the country.
So uniformity could be good.
It could be.
And you mentioned a couple different sort of standards, if you will, for when there should be more time. Do you think there should be a standard that should be applied in all cases where there an extension could be granted?
Well, there have been standards of sufficient cause, sometimes called good cause. The term special circumstances I've never seen before.
That's what I'm asking. What you
but
think a
sufficient
standard
cause
should
has
be.
been working, to my knowledge, to my experience. Never really had a request for postponement, a reasonable request for postponement turned down. So that's a good standard.
And so what your experience has been is between 7. So in some regions 7, in some regions 14.
7 has been the starting point. I've been searching my brain, trying to remember one that actually went forward to a hearing in 7 days. I can't think of one. There's always been, if a case was really going to a hearing, there's been a need for more time to get everyone's act together, to be able to present a credible record, first to recognize the issues, determine what the facts are, and then present a record that the board can make an intelligent decision from.
And just for the record, I would like to point out that I do not have a nefarious purpose.
Well,
I don't know which one of us or all of us you were accusing of that, but I don't have one.
well, I'm only saying that that's how the rules, as they're proposed, can be read. In fact, some might say it's the only way it can be understood because, as I said, there's no good reason to be doing it.
Yeah, Mr. Baskin, can you comment on, there's a trade-off here, which is we've got people who have sentiments regarding union representation or not, and it's in the interests of those people for things to proceed more quickly and in an orderly way. But then there's a trade-off in terms of the type of hearing that we then inherit when reviewing difficult questions about the unit composition, whether someone's a supervisor. In many of our cases, require a record that doesn't just get into how things work. We often require specific examples about how things have worked. In your own preparation, you're an experienced labor attorney, what's involved in your preparation with clients that have not previously had experience with the Act in preparing for a hearing?
Thank you. That's a good question because there may not be a full understanding without walking through. Every case is different first, but first it requires significant education of most clients as to what is involved first with the Labor Act, the Labor Board, and the hearing process. What are the issues that may affect, and just say construction industry, and we listed quite a large number in our comments. So it's educating them. Then it's finding out from them. They have to educate the advisor, the attorney, of what their business is like because every contractor operates differently, which is one of the reasons why the board has to hold the hearings in order to learn what their processes are like. We also find, and sometimes this is with the larger employers as much as the smaller ones, they don't know enough about their business. They know enough about their business to build things and to get things done, but in the peculiar way that the board looks at it and what the board is looking for in these hearings, the contractors have often given very little thought to how their workforce shapes up in comparison to that. So when you start asking them the questions, you get a blank look. We'll have to research that, they themselves, about their employee interchange or what their craft workers do and which sites they're on. In fact, recently, it was a little surprising to me, even who their employees were. It was a joint employer situation. The union seemed to be a little confused too, because they named the supervisor working for a different employer, which caused confusion in the service of the notice, confusion as to who was even involved, and everyone was confused. This is not atypical. It takes a while to sort these things out, to educate the client, have the client educate you and themselves, and then find people who can testify intelligently about what's happening and what to expect in cross-examination. And we're not here about whether a union is good or bad. We're just here trying to figure out what people do and what their benefits are and supervision and all these other questions that come up. And not everybody has all that information. Very few people have that at their fingertips. So that's just really the tip of the iceberg. It is a significant undertaking to go through one of these hearings. That's probably why more than 90% reach a stipulation, which we reach many stipulations. But when you have to go forward because there are serious issues, it's a significant undertaking to get the job done.
Thank you.
Thank you.